Hi everybody, this is Katie from Bench Press. Welcome to the next webinar in our series, which is on employee and labor relations. If you are participating in today's webinar and can hear what I'm saying, please use the chat feature and type yes so that I know that everyone's audio is working correctly. All right, thanks everybody. You just always want to make sure everything's working okay. Again, my name is Katie. I work here on the Bench Prep team as a customer success manager. Just one thing for you to know before we go any further, this presentation is being recorded. So the recording as well as the slides that we use today will be posted inside the course as soon as possible, most likely by the end of the day today. So to find the recording of this webinar after we host it, you'll go to the lessons section of the course, and then you'll scroll to the bottom of the table of contents where you'll see all the webinar recordings in a lesson category called webinars. So I will be here at the beginning of today's webinar to introduce John Newton, who is our host today, and I will also be here at the end if you have any product questions about Bench Prep HR. So I can answer any questions you have about the learning systems functionality itself or anything about the mobile app, anything product specific, whereas John, who is our resident HR expert, will walk through the content side of things. Once John starts, he will go over the content and then he will have 10 minutes at the end of his segment for content specific questions. After that, I will be on for a short segment of product questions. So just a quick reminder before we introduce John, and I will show this again at the end of the presentation. Please remember to sign up for our future webinars. We still have quite a few this season. You can find the link to sign up in the same place that you find the webinar recordings, which is the webinar category of the lessons. You can also go straight to benchprep.clickmeeting.com to RSVP for them. You can also join Bench Prep HR on social media to receive updates and interact with other HR professionals. We have a LinkedIn group for Bench Prep HR users, and we also have a Twitter and Facebook account. To find any of these, just search Bench Prep HR on that given platform, and the page will come up. So, as always, I'm very excited to introduce John Newton to you all today. He is our main resident HR expert. He holds the SPHR certification that some of you are studying for. And he's also a consultant with his own HR company, which is John Newton and Associates. He also teaches PHR, SPHR prep, not just as a webinar host for all of you, but at the university level at both DePaul and Northern Illinois University. So a few things to note before I officially hand things off to John. He may potentially use the chat feature throughout the webinar to ask your opinion on things or to have you answer questions for him. But if you do have any specific content questions for John, please wait and use the designated Q&A time at the end, just so there isn't a distraction during the webinar itself. John will do his best to get all of the questions answered at the end, and I will also be here to help him. So that's all I've got for me. I'm going to pass things over to John so we can start the content review. Just give us a few seconds or maybe a bit of the pause in the audio, but he will also ask you to confirm that you can hear him so that everything runs smoothly. Thanks, everyone.
Okay, everybody, this is John. Can you hear me? If you can hear me, go ahead and say hello. Fantastic. Great. So welcome. And Katie, I didn't even get a chance to tell you this, so I'll tell all of you this at once. I just heard from a student, just like all of you, who just recently studied utilizing the Bench Prep system and his PHR exam. So we'll give him a big applause on behalf of all of us, and I think it's good for us to hear these success stories. You know, this is a tough exam, and you know, it's not 100% pass rate because it's really demonstrating a strong body of knowledge, and this person's feedback was how very much he was able to maximize the utilization of these webinars and the Bench Prep learning system. So just folks, another reminder that it can be done. Okay, fantastic. And I'm going to go ahead here. And Katie, everything looks great on this side. Thank you for that handoff and that most recent thing you just sent my way. So let's start with a question here. An employee reports to Human Resources that she believes a coworker is being sexually harassed by their supervisor. What is HR's best next step? So go ahead and just decide. You think it's A, B, C, or D? Oh, and this is the time I'd like you to type them in. As Katie said, sometimes I'll ask. So let's see what you got here. Well, here's what's interesting, folks. Uh, okay, we're getting a couple more here. The actual answer is A, as in apple. Confirm the harassment with the employee and take measures to ensure the harassment does not continue. So what that means, folks, the reason it's not C, and I got to tell you that, you have to, what you want to take from this question is really when they have these, what's the next step? Well, conduct an investigation is a little too preemptive. It's first go to the employee to see, do they believe that they've been harassed, right? Confirm the harassment belief. I think that many of you might have gone with A directly if it was confirm the harassment belief versus confirm the harassment, because I think probably many of us in HR assumed, well, that means we've investigated and confirmed it. But what A really is go talk to the employee who we now have been told from someone else feels they're being harassed. If they do believe they're being harassed, then the investigation would come. So the answer is A. And you don't have to love all of these questions, but what you want to be good at is a willingness to say, okay, what can I learn from this moment? And in this moment is really what comes first. And first talk to the employee, then really do an investigation based on what you hear from that employee. All right, so what today is talking about is both the union and the non-union world. And for those of you who don't have a lot of union relations, I wouldn't worry too much. I think that, there's some factual terms and things you want to be aware of about how unions work. But I think fundamentally, what I have heard from students as they've taken the exam over the last couple of years is how relieved they were that it didn't feel so burdensome with the union piece. It doesn't mean you don't need to know it, but when we talk about employee labor relations, a lot of it is on the employee relations side of working with employees. So it's not just the union world. And what these next two slides just tell us is kind of the union story. And basically what I would just, I think I'm going to kind of encapsulate this pretty quick, but basically, why do unions exist? The fact that unions are in place is because employers were abusing their employees, right? And so what happens when you date? If you don't get what you want, you're going to go date someone else. And I think that that's kind of the same concept here. If you're being treated poorly by someone, why would you stay with them? Why would you not try and go somewhere else or find someone else that can step in and care for you the way you need? And that's really what this union world is that employers were locking employees into their plans. They weren't giving them restroom breaks. They were giving them buckets to go to the bathroom in. I mean, just some really horrendous stuff. And so, unionization really took off. Now, of course, in the 1960s, when we started to create many people laws based on how we were unfairly treating people in general and in the workplace, then what happened is union membership seemed to level off a little bit more, and then there were some peaks and spikes in certain industries. And then lately, 10 years ago, when we had some really crunch time in the economy, employers started to neglect their employees again a little bit and treat them poorly because they knew how desperate people were for jobs. And so those same abuses started to occur again, and unions started to get, a stronger foothold again. So just kind of keeping in mind, why are unions in place? Well, they're in place to ultimately, at least that's what the unions would say, is look after the employees that when the employers are not. The general rule of thumb, what this slide has us think about, and I'll just, for those of you who have never touched unions, is there's two primary ways in the United States that unions are formed. One is they have employees reach out to unions and say, would you consider representing us? And then that sort of starts a process. Or two, and what's often more common, is the unions will reach out to employees, right, and say, we'd like you to consider us to represent you, and then that will start the process. What happens is, for there to be an official election, the National Labor Relations Board has to approve an election. And for an election to approve, there has to be what we call these authorization cards. And they're kind of like a pre-vote that the group that is ultimately seeking to be represented has to sign and say, we would strongly consider voting in a union. And once the National Labor Relations Board has a strong enough percentage of those signed, it's the mid 30% range, then the National Labor Relations Board will say, okay, we're going to direct an election and let a vote happen. Collective bargaining, we have another slide on it, but I'll just sort of talk to you about that right now, because many of us have probably heard that language on the news, and what is it? All collective bargaining is contract negotiation. But keep in mind, I'm going to give you a hint for an exam question you might come across, right? Collective bargaining is negotiating a contract or renegotiating a contract. So people often forget that once a contract, and usually the contracts are 2 or 3 years, you got to negotiate that contract, but then we often have to renegotiate every 2 years or every 3 years the terms of the contract moving forward. And so collective bargaining can happen at any time through that process, before a contract is in place or as one is ending and we're trying to re-up it. And so if you're re-upping it, the terms of the existing contract hold in place until a new one is voted in or not. Two words that I definitely want you to know are the deauthorization and decertification. And what those words tell us is a deauthorization says, we, the union membership, are disappointed in our union. You're not representing us in the way we think you should be. And so what we do at this point is we vote, and the National Labor Relations Board has to allow this, we vote that we want to deauthorize the union. And what happens with deauthorization is they don't go away because there's still a contract to finish, but they will not be able to sort of enforce some of the what we would call union security clauses, which are primarily financial things. We can't require unions to pay union dues, union members to pay union dues once we've been deauthorized. But because we still have 6 months on a contract, we the union have to represent our employees. So it's basically a neutering of the union, but because there's a contract, we can't get rid of them. Decertification is when we vote the union out, and literally that's done in the last final months of a contract. Instead of a renegotiation, it's a vote to get rid of them. And the unions fight this because it's a business, but for an employee group to say, we don't want you anymore, the union typically has poorly represented them. Is typically why they're decertified. Just out of curiosity, if anybody has ever worked at an organization where you've worked through a decertification or deauthorization, go ahead and put a yes or type a line or two about it in the chat function. If not, you don't have to type anything, but I'd be curious if we've got someone who's lived and breathed through a deauth or a decertification. I don't see anyone typing, so I'm guessing no. All right, so employment at will. We've seen employment at will, gosh, multiple times in this course, right? All the way back to our second functional area. After we did business management and strategy, then we did, we looked at sort of the employment side, and that's why we talked about employment at will. But we're bringing it up again because what employment at will does in the employee relations standpoint is it tells employees that we can end this relationship with or without notice. We don't have to give you any reason, and we don't have to give you any notification. However, when an employer has an agreement with the union, then employment at will is typically negated. In other words, typically because we've committed to the union that we will not end the relationship with any of our employees that are covered under the union for a period of time. So it's kind of an interesting nuance because here's a question, type a yes or a no. I don't have a voting function here that I can easily do, but is the individual employee under a contract in the union relationship? Is the individual employee under a contract in the union relationship? Yes, each employee has a contract, or no, each employee does not have a contract. All right, the actual answer is no. The contract is between the employer and the union, but the employees vote on it, right? So they're the ones who say we want it or we don't, but they're not technically contract employees. The contract is with the union and the employer. Therefore, technically, we can still use employment at will. But if we did, you can bet the union representing us would say, wait a second, you're violating the agreement that the union has with the employer. But there's not. An employee in a union is not under a contract themselves. They are represented by an agreement / contract that the union has with the employer. All right, let's do another question here. Which of the following is not one of the 3 barriers that prevent women and minorities from advancing to senior levels? All right, what do you think? Go ahead and type in your answer. All right, I think almost everybody's still typing there, finishing up. The answer here is actually A, executive barriers. Now, I can understand why many of you didn't select that because when you think of senior level, you think of executive barrier, right? But when the research and what the the learning systems really drive us to think about is yes, there's an executive barrier, but it's not literally executives who are saying don't step up into this role. It's not considered in and of itself a technical barrier to research to figure out. It's sort of an event, it's an organizational level, but in and of itself, the executives are not the barrier to success. What are the things that are preventing women and other protected classes from reaching the senior levels? There's societal things, the sort of the perception of the place that women have or don't have, or African Americans have or don't have. Structural barriers. That really would include any senior executives that might be preventing people from growing up. That's the actual technical barrier language. Executive barrier is kind of like a made-up language barrier for this. And then governmental barriers is really the ability to sort of not be compliant with all of our laws, because as you know from this course alone in your own experience, there's many laws that say what we should be doing, but because there's not enforcement of many of these laws, this governmental concept, A is your actual answer. So, but don't beat yourself up if you chose A. I can understand why you would, but now moving forward, just kind of think of it more as what's a true barrier versus what's sort of a definition of part of an org structure, and that would be your executive barrier. All right, so collective bargaining, I really already spoke to this in the previous slide, but I just wanted to kind of remind all of you, when you see that, it's contract negotiation. Contract negotiation, that's all it is. The things that we have to negotiate as far in the union world, like the National Labor Relations Act says you must negotiate are the wages, the benefits. The things that we are optional to negotiate are often retiree things like access to a 401k, maybe once you've retired, some sort of severance. Those kind of sort of things become optional, but like the healthcare stuff, sort of those fundamental barriers are not. Those are required. And then the things you can never negotiate are anything that violates the law. And so you could not negotiate into an agreement. You must be under 40 to be promoted to an executive. Like that would be a violation of law, and so you could not negotiate that. Okay, who can tell me what a SALT is? So let's take a minute and have any of you that want type in some language, your own language. What is a SALT? We're going to look at some union and employer rights at this point. And as you're typing, it's fun to see. I say a lot of familiar names from the bench prep system as I go on, from previous webinars, so it's nice to see all of you again. I'll wait just a minute or so to give. Okay, it does look like from the people who have typed, we've got a pretty strong knowledge of it. I'm just going to go with Pete and Paula's comments because Pete, I think your union pays someone to join the organization targeted for unionization. They may pay them. They don't always pay them, but typically there's like a stipend. And then Paula, I just love your line, an undercover union rep. It sounds so HR can be so sort of straightforward and conservative. So it sounds like we have spies and it's kind of fun, but that really is kind of the case. SALT might be an undercover to start with. So basically what happens, the right of a union is they can have an existing union member, because remember, people might not be employed but still be members of unions, right? That's how it typically works. And so if someone is truly looking for work, they can't be faking it. They have to really want a job. They can go to represent the union and try and get a job at the employer that they're targeting, as Pete said. And then the employer doesn't have the right to not hire them, even if they find out this person is a SALT. Because as long as they're qualified to do the job and they were the candidate of choice, they then would be hired. So the union has the right to get those SALTs in there. It doesn't stay undercover for very long because that would kind of defeat the purpose, right? Once they start, they'll basically say, hey, I'm a member of fill in the blank union, and we would be great to, represent, this employee base. Other rights that the union has is we have the ability to do what are called home visits. We can show up at your homes, and you say, well, how would we know where you live? That's the Excelsior list. Once an election is approved by the National Labor Relations Board, the union has a right to ask from typically HR. We want a list of how to contact all of the people who are potentially going to be represented by our union so that we could show up at their homes. And then this offsite meeting, union can host, and they do this in church basements, in back rooms of bars, come talk to us about why unions are great. On the right-hand side are some employer rights. And what these rights tell us is we, as an employer, can bring all of our employees into a room, a captive room, so to speak, and tell them our thoughts on this unionization attempt. As long as we're telling the truth, we can talk all day long. What we can't do is we can't threaten. So we can't say, you will lose your job if this union is voted in. What we can say is, last time a union went into our plant down in Michigan, we did have to do 22% employee layoff. As long as it's factual based and not threatening, the employer has the right to do that all day long. Okay, I'm going to teach the slide and then I'll pause and answer any questions you have up until this point in time. What this talks to us about is this concept of right to work. And a right to work state is a state where an employee cannot be compelled to join a union for employment. Okay, so first of all, Is Illinois a right to work state? Yes or no? Go ahead and type it in. Is Illinois a right to work state? Got still a few people typing, so we'll wait to not jump on them. I'm not talking at this moment. That could be why you're not hearing audio. Are you hearing audio now? For those who said that you can't, Dean, for example. That's because I'm not speaking. I was taking a break. Hopefully it's not going in and out right now because we've not changed anything. My technology people, if they could notify they're listening as well. Okay, it looks like some of you are and some of you are not. My technology people are looking into it to see what might be causing that. I'm going to go ahead and move on because I'm getting some thumbs up that I can be here. So yeah, maybe if need be, it looks like Tyler reloaded, so we'll do that. I'm going to need to move forward for the sake of time. My technology people are looking behind the scenes as well. Nothing has changed on my part here, folks, so I don't know why this is happening. Anyhow, let me move forward here. Illinois is not a right to work state. You can be compelled to be a union member for employment. It is not a right to work state. All right, so let me go through these here. It sounds like some of the dial-in is where people are having some issues here. I'm not sure, but Bench Prep is sending something into you as well. Allison, I'm not typically looking at the chat, but I happen to catch your chat because remember, we don't take the questions throughout, but I happen because I was hearing some dial-in issues, so I'm going to address your answer right now. This is a federal exam, so yeah, I'll sort of throw it back. What do you think? Do you need to know which state from a federal standpoint? Yes or no? You bet, Allison. Good job. We don't need to know which state. I just did that to kind of engage you guys to think about it because this is a federally based exam, so they won't go to the nuance of state to state. So good question, Allison. So anyhow, folks, all right, let me go through this slide for you here. So right to work state, once again, is a state where you can't be compelled to be a union member if you want to be employed by a company. Illinois was just my example. It was you can. We are not a right to work state. Closed shop. What a closed shop is it's where in order to be employed by a company, you must already be a union member. So we are not going to hire you unless you are already a union member. A union shop would say, we will hire you if you're not a union member, but within a period of time, usually 30 days, you must join the union, okay? Neither of those, right, closed shop or union shop, would be able to be in a right to work state because we can't compel you to join a union in a right to work state, but both a closed shop and a union shop, we are compelling you to join the union. An agency shop does not require employees to join a union, but they might require you to sort of pay the equivalent of union dues or some other union-related dues because you're in the bargaining unit. So technically, an agency shop could be in a right-to-work state because we're not making you join the union. But anytime in the recent past that the courts have looked at agency shop, they have kind of shot the concept down because they're saying, all right, you're not making them join the union, but they're paying the equivalent dues. It's as if you've made them join a union. So in other words, in practice, an agency shop would also not be allowed in a right to work state. And then an open shop is you can work with us. We might have a union membership, but you don't have to join that union. And those, of course, could be in right to work states. So I would want you to know those four. So before I move on, I'll just pause here before we do sort of our second half of material here. Any questions on this particular slide? And as I'm looking at some of the types, yeah, Pete, certainly as an HR professional, you need to know if you're in a right to work state or not. But for your certification exam, absolutely, it's not like they're going to say which one of these states doesn't belong. So Karen, so again, you likely won't have a certification exam test question on it because the courts really sort of debate this, but your question about is an agency shop able in a right to work state, and technically yes, because look, they're not requiring you to join a union, but in practice, they've lost many claims in courts because what they're being required to do is pay the equivalent of being in a union, and a lot of judges' common law interpretation is, well, then you're basically making them join a union. But technically, by definition, no, because they're not making you join a union, you could have those in a right to work state. All right. Tyler, typically the fees for the agency shop go to the union. That is another reason why it's a problem. Sometimes the fees can be designated to like a nonprofit, and the courts are usually more comfortable with that. If the union isn't benefiting from those dues, then the courts are a little better with that. So it's really odd. Sometimes they can go to like a nonprofit church or a volunteer organization, and then those often have the approval of the courts. It's kind of a I don't know, odd thing, but that's how that works. All right, I think I got those questions there. You bet. Okay, so a couple of common law tort claims. And remembering what common law is, folks, common law is court case decisions, right? What are the courts saying? And so when we look at these four here, defamation, fraudulent, misrep, and so on, a tort claim is usually a people-related claim, injury of somehow, either people or organization. And so defamation is when something is said untrue about someone and it causes harm. It has to be both. So I could go online and say something bad about Tyler right now, untrue, bad. It doesn't even have to be bad. It could just be untrue. Tyler is married, okay, and he's not. He could say, well, you've defamed me. I want to be known as a single person, and you've said I'm married. Well, that's not defamation if suddenly, because they said he's married, he's unable to date for the rest of his life, then he could say, John, you've caused me harm, you've defamed me. So defamation is A, an untruth, and B, an untruth that caused harm. Fraudulent misrepresentation is when we do something as an employer, even if it wasn't intentional, that ultimately ended up not being true and caused harm again. So think about this. Say a manager says to an employee that they're recruiting at the time, in 12 months, you will be a supervisor. Guarantee it. And this candidate says, I'm going to take this job. I'm going to quit my current job because I want to be a people manager. And now I've been told in 12 months I will be. Takes the job. 12 months later, at no fault of his own, is not a supervisor. What this person could make a claim is, you misrepresented. You told me I'd get this and I didn't, and I was harmed. You know, I could have stayed where I was at, or I could have taken a different job and definitely been a people manager. So this fraudulent misrepresentation concept. Employer expectation of employee loyalty sort of flips the deck. You don't see it a lot, but it's when an employer can go after their employees for causing harm, for saying basically untruths, right? Or let alone sharing information that's confidential. But it's much more kind of the thing of, I work at fill in the blank fast food restaurant and they serve hot horse meat. Everybody starts going there because they're afraid of the horse meat. Well, the reality is there is no horse meat being served. So this employee just made something up and it got out there. An employer could go after that employee for the harm. And then non-compete, it's not, it says here non-complete. It really is non-compete. That's just a typo. Sorry about that. A non-compete clause is when an employer has an agreement with the employee that when they leave, or even when they're employed, but it's typically to hold them when they leave, they can't go to the competitor right away. They can't steal business from them, those kind of things. And so typically there's timelines, 3 months, 6 months. There are very specific things around what a non-compete is. Those of you who work in California, non-competes are typically unenforceable because the courts want to make sure, yeah, we don't want you stealing business, but we also want you to be able to get a job. So if, usually there's mileage like within 30 miles of where this employer was, as well as time around it. And if you have questions on anything I'm saying, I will definitely pause again near the end to give you a chance to ask those. We already spoke about negligent hiring on a previous slide, so now we're going to talk about negligent retention. Negligent retention is when we employ someone that we probably should have gotten rid of, and we didn't, and then they caused harm to someone. So in this whole employee relations world, think about, let's say Bob hits Mark in the workplace, and we give Bob a verbal write-up. But was that really good enough? He caused harm to another employee. Well, 2 days later, Bob goes and shoves Amy down the stairs, and Amy breaks her neck and dies. Well, Amy's family could certainly have a negligent retention lawsuit against the employer by saying, you knew you had a violent person and you did next to nothing. That would be a problem. In good employee relations in both labor and non-labor environments, union and non-union environments, you want to consider what are you doing to properly discipline your people. So starting on the right-hand side, we talk about what are some steps that we should take as an employer, having a strong disciplinary process that's, in policy, that's been trained and educated to the employees, and that's consistently used. Now, just because you're in a union world doesn't mean that the disciplinary process isn't enforceable. It absolutely is enforceable, but sometimes in the union agreements there might be additional steps that are involved or something like that. But a union does not negate a company's disciplinary process. On the left-hand side are just a couple of terms you should think about in both the union and non-union world. Insubordination, that's when it's a legal right for an employer to fire someone for being insubordinate. Insubordination is when an employee refuses to do something that is legal, ethical, and safe. If an employee refuses to do that, we could automatically fire them. We could skip all steps because it's insubordinate. When you write unemployment claims, FYI, if you're ever the author, if you're responding, or you're writing termination letters, you want to always try and put insubordinate in there because the courts usually say if someone was insubordinate, it was a legal thing they were asked to do and they didn't do it, you'll almost always win any unemployment claim. Open door, that simply is maybe a union avoidance technique where management says you always can come to us without fear of retaliation to talk to us about some of your concerns that you might have in the organization. And then skip level interviews. This is when you're trying to find out information from your employees, and so instead of just going boss to employee, maybe you go executive to employee. So you skip a couple of layers to try and really dig in and figure out what's going on. Let's get rid of the middle person. Let's ask some good questions. Now on your exam, either in here or on the certification, make sure you read the question well around skip level interviews, because sometimes they'll talk about, a supervisor. Can a supervisor be part of a skip level? Of course they can. We assume the supervisor is the direct boss, but remember, there could be an employee, a lead employee, then a supervisor. So I just share you that because I've had some people disappointed when they guessed the wrong answer because they thought you couldn't do a skip level with a supervisor. Of course you could. All right, I'm going to focus on the right-hand side. We actually look at self-directed work teams in HRD, so just kind of as a heads up, you'll notice it's not uncommon to see things more than once. But on the right-hand side, I wanted to talk about committees here because there's a key test-taking moment here. You know, a committee is, usually committees are ongoing, and then the people that sit on those committees change periodically, which is fine. But the reason we bring up committees here is, you know, committees can be good because it gets people engaged. But the challenge with committees is when we're having committees make decisions on wages or working conditions. You know, how much somebody should make, and, you know, should they get a fancy office or a cubicle. What the National Labor Relations Board, based on the National Labor Relations Act, has said is caution on having employees make decisions on wages and working conditions unless that's their job. So you as an HR manager might make a decision on how someone gets paid. You as a customer support analyst should not be making decisions on how much someone gets paid. And if you are, what the NLRA is saying is maybe you're acting like a union, and if you're acting like a union because they negotiate wages and working conditions, then we might have to recognize you as a union. That's what that employer-dominated union concept means on your slide here. It's a fancy word for you've made your committees like unions. We've created a committee, now you're making decisions on wages, and basically you're a union that we put together. So be cautious of that. All right, we've got another question here. We've got about 5 or 6 minutes, so start swirling on questions you have, and then I'm going to open it up for general questions, as Katie will as well, for any product questions. But this is just a quick factual one. Under the Taft-Hartley Act, the president has the power to stop a strike or lockout. Put the letter or the days. What do you think? The answer is C, 80-day cooling off period, folks. You know, this comes from the labor management law, also, you know, known here as the Taft-Hartley Act. I honestly don't know if that, I've never had someone report that question on the certification exam, but I know that we, and our resource list of questions ask you that, and I think a lot of us get it wrong. It's sort of an obscure answer, 80 days, but so I wanted to address it. Most times they're not asking questions on days. Just anytime they really question on days, I usually point those out in our webinars. But because this was a hard question, I just wanted everybody to know it's actually 80 days. I know it feels sort of arbitrary, but it is. So I'm not denying that one, nor would bench prep. It's a legal question. I just don't know that you would spend too much time memorizing that. All right, and as we're getting close to wrapping up, I want to address this one piece of union piece, and then I'm going to speak to a law or two, and then it's any questions you have about this content, or even things like studying for the exam. So I really want to be able to help you with that. But I think on this slide, on the left-hand side, we talk about unfair labor practices, or ULPs, and you should be familiar with the ULP. And what the ULP simply is, it's a violation of something. It might be a violation of the agreed contract. It might be a violation of the handbook policies. It might be a violation of the union agreement itself. And so what you want to, or the National Labor Relations Law, right, the act. And so a ULP claim can come from an employer, from the union, or the employees via the union, or on the union. So it can really come from anywhere. But basically a ULP claim is someone's violating something, and the National Labor Relations Board or the regional representatives are required under law to investigate to see if it's an actual. You'll hear in the city of Chicago, whenever our teachers unions go on strike, the teacher union is always claiming that the city is not coming to the bargaining table and bargaining fairly, and so that's usually a ULP you see all the time claim. Now, it's not often validated, but that's the claim. On the right-hand side, the strike and boycott concept, what I want you to remember about this is that under the law, under the National Labor Relations Act, employees who are union members in most circumstances have the right to strike. And so we've got here your economic strikes. That's when people strike over money. Typically, so you know, you can be fired for striking over money because that's not one of the things that protects your job. Now, it doesn't happen a lot. Usually we negotiate out, but technically, striking over money is not something that an employer has to give into. Striking over an unfair labor practice claim is legal, and absolutely you cannot be fired for. So if you're striking because you think your rights have been violated under ULP, you always have to be reemployed. And then a wildcat strike is when the unions go on strike, the union membership goes on strike without the agreement of the union that represents them. And those kind of strikes you can be fired with. So for your exam, I think those are 3 important talking points. The rest of the things here, employer, worker, or public, what those are is those are often done pre-unionization, and they're kind of sort of the striking with the signs in front to get recognition. Hey, employees, let us represent you, so we're in front of your company. Hey, employer, let us represent you because let us represent your people. So that's the recognitional. And then informational is when we're trying to get the word out to the people that this place won't let us represent their people. You will also see informational striking with the rat. If you've seen those big rats outside of companies, a lot of times that's when the unions will go off and say, they're not, this is not a union site, and it should be. I had one just by my house the other day. And then lastly, before I talk about a few laws here, it is perfectly legal to do what we call a lockout. If the employer thinks that the union membership is about to strike or do a sit-in or cause some sort of harm, we can lock them out. But now we've just learned the president can overrule that for 80 days, sort of a cooling off period. And then lastly, and then you can start typing in your questions that you have about this content, about studying for the exam, and then if you've got any product ones as well, we'll capture those separately. Just as a reminder, a key law here is your National Labor Relations Act. This is the law that says employees have the right to organize, so try and form a union. It's a perfectly legal, protected right for 2 or more employees. They have the right to form a union. They have the right to collective bargain, which is negotiate an agreement, how they're going to be represented. So very protected rights throughout the country. It's a very important law. And then I think I will just point out the Railway Labor Act, because some of you might be in these industries. Railroads and airline industries are covered under the Railway Labor Act, and it basically has the same protection for those industries that your National Labor Relations Act has for all other industries. And at this point in time, I just like to remind you, federally speaking, folks, this exam focuses on federal laws, so don't get yourself trapped when you say, I know I live in Elmhurst and my company's in Bensonville and we have to do it this way. Is it driven by federal law? If it is, that's the thing to keep in mind. If it's driven by a local ordinance, let that go. And then one last thing, I did it, as Katie mentioned, I teach courses live with people in a classroom setting, a little different than over the internet. And I taught a class last night, and I had a student come up, and I said, I just wish I could tape you. She got a lower score on a test exam, and she said because she kept changing her answers. So folks, think thoughtfully about the answer, but once you select an answer, unless you really know you misread a word, stick to your first answer. Your first answer is almost always right. So at this point in time, Katie and I are going to start addressing any of your questions that you might have. So I'm going to do a little scrolling because my screen moves, so to see if I can catch this. Under a ULP complaint, is job protection afforded only if it's validated in court. If you mean by court the National Labor Relations Board, that's really what that is. So the National Labor Relations Board is the court of decision when it comes to your ULPs, and depending on what they say. If it's an unvalidated complaint and they say, no, we agree, there's been no violation, then an employer has the right to take action. And, you know, if it was a reason they fired someone, then they could stick to that firing. Pete's asking about the court cases. You know what? I'm going to kind of give you, I think, a little weight off of your shoulders. For the certification exam, HRCI does not typically ask you which court case said what. What they will do is they might reference a court case and then a piece of information, and if you know the court case, it allows you to better answer a question. But even if you don't know the court case, as long as you know the concept, then you'll be okay. So you might have 6 court cases that all speak to adverse impact, which is unintentional discrimination. As long as you know what adverse impact is, you certainly don't need to know the different court cases. Now, I know many of you are saying, but gosh, in bench prep, we really question you on some of our test questions on which court case said what. We do that to make sure you're reading through. So you may struggle a little with those court cases, but remember, what we're really preparing you for is the certification exam. So what I would recommend when you read through the court cases, highlight the concept. Are they talking vicarious liability? Are they talking discrimination? Are they talking adverse impact? And as long as you know the concept, that's what will help you. The court cases just give you context around the concept. So I would honestly, I certainly, if I were sitting for HRCI today, I would not be memorizing all of these court cases. You know, there's a couple of key ones that are like A-list HR cases that, you know, are nice to know. But again, are they going to be, you know, if you don't know, was it Griggs versus Duke Power versus Farragher versus City of Boca Raton? I think you'll be fine on your exam. I genuinely believe that, and that's what students are telling us. I got to go back here, see if I can. You know, Allison is asking about how often is exam content. I briefly spoke to that at the beginning, but I would first recommend go to the HRCI website, and they address this. So read their language, because you know you have to get it from them firsthand would be my recommendation. But what they basically say is, you know, it's typically about a 12-month run where content on the exam, if there's been a change, will count towards your exam. So what I was saying at the beginning of today, and I'll kind of reinforce now, is, you know, if the ACA law changes today, it's not going to count towards your exam tomorrow. What might happen is on your exam, you might have a question around it, but what HRCI is doing is they're building questions to test for reliability and ability. Are these well-written questions? So they might slip them in, but those are part of the questions that don't count towards your score. You won't know that, unfortunately, so you might like, oh, I don't know that. But a good rule of thumb is if it, you know, a good year before anything that's changed out there in the world will count towards your score. But I definitely encourage you to all read the language on the HRCI website or call them directly. Okay, let me just see what else here. Executive orders is not considered federal law, so you know fundamentally it's if you know if it's not an act, the executive orders and all those changes and rechanges are typically not what are test worthy. But again, that's when you want to go look at the HRCI language to see how they sort of address how they're dealing with. Executive orders often fall into sort of court case concept as well. There's been some modification to laws, but because those are so nuanced and they can be overridden, as so many have been overridden in the last 10 months, that it's still the basic facts of what these laws teach us versus what the executive decision interpret is where you need to go for on your exam. Okay. So the question is, are there exceptions to at will for bargaining employees? Well, the exception is depending on how the contract is written. So there's typically in every union agreement, there's language that says you're going to guarantee to go through the disciplinary process or the mediation process before ending a relationship. And if an employer has agreed to that language, then typically the contract is what becomes those steps. So we've agreed to follow this process, but it's really no different than a non-union agreement. If you have a disciplinary process, you don't just get to willy-nilly, as they say, use at-will employment without risk of someone coming back and saying, but you promised me my progressive disciplinary. So unless the agreement, the contract, or your handbook is written with the exceptions to the rule, then even though at-will is legal, you still have to follow what you've committed to your employees or be at risk of a judge saying you violated their policy or their contract. How can a person be a member of a union without being a member of a company? That's how it works. So unions are their own private organizations that people join, and then they find jobs because they're members of that union typically. So there are two different things. It's like basically being a member of a club, and because you're a member of a club, you get entryway into certain places. So that's how unions work. It's not the other way around. Now, some union membership requires some work experience first, and that's where it becomes a bit catch-22, and that's why some of these union shops will give you a time to get that on-the-job experience. But just because you lose a job doesn't mean you lose your union membership, because if anything, it allows you to be employed at another organization quickly. Katie will reinforce how you get access to these webinars. My short answer, folks, anytime you're looking for anything, scroll to the bottom of the lessons. All the good stuff is there. I think Katie will say that in a nicer way, but that's pretty true. Economic complaints are not job protected. Correct. That's an economic strike, for example, does not guarantee job protection. And then I think I caught all of yours. Katie will give me a heads up if not, but I want to give it to Katie to address some of the product things that are flowing out there as well. So you're welcome to all of your answers. Katie, I'm going to hand it back to you in our last 4 or 5 minutes to address any outstanding questions as well. And this might...
Hi, everyone. Thank you so much, Sean, for being with us today. I will now take any questions about the technology or the product. As for webinar recordings, Sean is correct. There will be a recording of this webinar. It will be in the course later today. To get to it, you will go all the way to the bottom of the lesson section where there's a section called webinars, and there you'll find a lesson that has today's date in it. That will be where today's webinar is. And the previous webinars that we've had will be in similar lessons with the dates and content areas that they covered. So again, I can take any other product questions. Is there an actual manual? So there isn't a physical manual. There are a couple of lessons called How to Use This Course, and those will take you through how the course and the product work, how to go through the platform. As far as workbooks are concerned, we don't have anything of that nature. If you purchase the McGraw-Hill PHR, SPHR prep materials, they're very similar to what's in the learning system, so you can sort of use those as a guide if you'd like, but we don't have any affiliated workbooks. I will stick around for a couple more minutes, just if anyone has any other tech questions. You're very welcome. It does look like we're reaching time. Oh, I'm having trouble with the mobile app. Where can I go for help? So if you're having issues with the mobile app, I would go to the help desk, which is helpdesk.benchprep.com. From here, you can either contact our support team. There are also a number of articles where you can see how to do specific things with the mobile app. I'll type that into the chat field as well, the URL for that. So that would be where to go if you're having issues with the mobile app. Again, if you're using the mobile app, make sure that you're using the BenchPrep HR companion app as opposed to the BenchPrep companion app. Make sure that it has that HR in the title. So thank you all again for being with us today. We do have more webinars coming up. Our next webinar will be in November, which is kind of weird that November has come up so quickly. But our next webinar will be risk management. John will also be hosting this. You can sign up at benchprep.clickmeeting.com just as you signed up for this one. And you can also sign up for any future webinar that we're holding. So thank you to everyone who attended today. We're so glad to see so many of you here, and we will see you next time. Thank you.